his moral standard to a breaking strain. But, though his theory broke down, perhaps the most striking evidence of his wonderful intellectual superiority is that he convinced the Democrat, Joseph Story, a man who had been nominated by Madison to oppose him, and of undoubted strength of character, of the soundness of his thesis. In 1769 King George III incorporated certain trustees of Dartmouth College. The charter was accepted and both real and personal property were thereupon conveyed to this corporate body, in trust for educational purposes. In 1816 the legislature of New Hampshire reorganized the Board of Trustees against their will. If the incorporation amounted to a contract, the court was clear that this statute impaired it, therefore the only really debatable issue was whether the grant of a charter by the king amounted to a contract by him with his subjects to whom he granted it. After prolonged consideration, Marshall concluded that it did, and I conceive that, in the eye of history, he was right. Throughout the Middle Ages corporate privileges of all kinds, but especially municipal corporate privileges, had been subjects of purchase and sale, and indeed the medieval social system rested on such contracts. So much was this the case that the right to return members of Parliament from incorporated boroughs was, as Lord Eldon pointed out in the debates on the Reform Bill, as much private property as any of your lordships' titles and peerages. It was here that Marshall faltered. He felt that the public would not support him if he held that states could not alter town and county charters, so he arbitrarily split corporations in halves, protecting only those which handled exclusively private funds, and abandoning instruments of government, as he called them, to the mercy of legislative assemblies. Toward 1832 it became convenient for middle-class Englishmen to confiscate most of the property which the aristocracy had invested in parliamentary boroughs, and this social revolution was effected without straining the judicial system, because of the supremacy of Parliament. In America, at about the same time, it became, in like manner, convenient to confiscate numerous equally well-vested rights, because to have compensated the owners would have entailed a considerable sacrifice, which neither the public nor the promoters of new enterprises were willing to make. The same end was reached in America as in England, in spite of Chief Justice Marshall and the Dartmouth College case. Only in America it was attained by a legal somerset which has disordered the course of justice ever since. In 1697 King William III incorporated Trinity Church in the city of New York, confirming to the society the possession of a parcel of land adjoining the church, to be used as a churchyard for the burial of the dead. In 1823 the government of New York prohibited interments within the city limits, thus closing the churchyard for the purposes for which it had been granted. A compensation was refused. It appeared to be a clear case of confiscation, and Trinity resisted. In the teeth of recent precedents, the Supreme Court of New York decided that, under the police power, the legislature of New York might authorize this sort of appropriation of private property for sanitary purposes, without paying the owners for any loss they might thereby sustain. The court thus simply dispensed the legislator from obedience to the law, saying in effect, although the Constitution forbids impairing contracts, and although this is a contract which you have impaired, yet in our discretion we suspend the operation of the Constitution, in this instance by calling your act an exercise of a power unknown to the framers of the Constitution. I cannot doubt that Marshall would have flouted this theory had he lived to pass upon it, but Marshall died in 1835, and the Charles River Bridge case, in which this question was first presented to the Supreme Court of the United States, did not come up until 1837. Then Joseph Story, who remained as the representative of Marshall's philosophy upon the bench, vehemently protested against the latitudinarianism of Chief Justice Taney and his associates, but without producing the slightest effect. In 1785 the Massachusetts legislature chartered the Charles River Bridge Company to build a bridge between Boston and Charleston, authorizing it, by way of consideration, to collect tolls for 40 years. In 1792 the franchise was extended to 70 years, when the bridge was to revert to the Commonwealth. In 1828 the legislature chartered the Warren Bridge Company expressly to build a bridge parallel to and practically adjoining the Charles River Bridge, the Warren Bridge to become a free bridge after 6 years. The purpose, of course, was to accelerate movement by ruining the Charles River Bridge Company. The Charles River Bridge Company sought to restrain the building of the Warren Bridge as a breach of contract by the state, but failed to obtain relief in the state courts, and before the cause could be argued at Washington, the Warren Bridge had become free and had destroyed the value of the Charles River Bridge, though its franchise had still 20 years to run. As Story pointed out, no one denied that the charter of the Charles River Bridge Company was a contract, and, as he insisted, it is only common sense as well as common justice and elementary law that contracts of this charter should be reasonably interpreted so far as quiet enjoyment of the consideration granted is concerned, but all this availed nothing. The gist of the opposing argument is contained in a single sentence in the opinion of the Chief Justice, who spoke for the majority of the court. Quote, "The millions of property which have been invested in railroads and canals, upon lines of travel which had been before occupied by turnpike corporations, will be put in jeopardy," unquote, if this doctrine is to prevail. The effect of the adoption by the Supreme Court of the United States of the New York theory of the police power was to vest in the judiciary, by the use of this catchword, an almost unparalleled prerogative. They assumed a supreme function which can only be compared to the dispensing power claimed by the Stuarts, or to the authority which, according to the Council of Constance, inheres in the Church to grant indulgences for reasonable causes. I suppose nothing in modern judicial history has ever resembled this assumption, and yet, when we examine it, we find it to be not only the logical, but the inevitable effect of those mechanical causes which constrain mankind to move along the lines of least resistance. Marshall, in a series of decisions, laid down a general principle which had been proved to be sound when applied by ordinary courts, dealing with ordinary social forces and operating under the corrective power of either a legislature or a praetor, but which had a different aspect under the American constitutional system. He held that the fundamental law embodied in the Constitution commanded that all contracts should be sacred. Therefore he, as a judge, had but two questions to resolve. First, whether in the case before him a contract had been proved to exist. Second, admitting that a contract had been proved, whether it had also been shown to have been impaired. Within 10 years after these decisions it had been found in practice that public opinion would not sustain so rigid an administration of the law. No legislature could intervene, and a pressure was brought to bear which the judges could not withstand. Therefore, the court yielded, declaring that if impairing a contract were, on the whole, for the public welfare, the Constitution, as Marshall interpreted it, should be suspended in favor of the legislation which impaired it. They called this suspension the operation of the police power. It followed, as the police power could only come into operation at the discretion of the court, that, therefore, within the limits of judicial discretion, confiscation, however arbitrary and to whatever extent, might go on. In the energetic language of the Supreme Court of Maine, quote, "This duty and consequent power override all statute or contract exemptions. The state cannot free any person or corporation from subjection to this power." all personal as well as property rights must be held subject to the police power of the state." Once the theory of the police power was established, it became